Hello, good afternoon, everybody. Welcome to today's webinar. My name is Jane Stevens. I'm the training manager here at Zolo, and I'm excited today to be joined again by Michael Solomon. He's going to be doing part 2 of our 4-part series, talking about the landlord tenant bootcamp. Today, specifically, we're going to be focusing on lawful and unlawful clauses. So I know there's going to be lots of questions about that, so feel free to ask throughout the session. And then, of course, we'll leave some time at the end. So hello, Michael. Nice to see you.
Hi, nice to see you again, Jane.
Yeah, thanks for joining me.
Thank you.
All right, so let's get started.
Okay, so last week we talked about forming the standard residential tenancy agreement. And this week we're going to talk about adding addendums and adding clauses and things of that nature to our agreements, because sometimes what the the standard lease provides for us is not necessarily everything that we're looking for, and we're looking for a little bit more than what we require out of the standard form of lease. So sorry, I've just been muted.
Sorry, I was muting everybody else. Didn't mean to mute you too.
That's okay. So what I was going to say was I've actually gone ahead and I've pulled the information off of our server. So I'm going to do some screen sharing and things of that nature today. So then we can take a look at the additional clauses that are lawful that we put into our landlord's agreements that would definitely be able to help Zulu real estate agents. So right now I'm just going to share my screen with everybody so everybody can see. And we will bring this up here. Bear with me, I'm on a computer that I don't really know how to use. So hopefully you folks will be able to see everything okay. Okay, perfect. Okay, wonderful. So this is part of the package that I was talking about last week, where this is accessible to Zulu real estate agents for free from our firm. We'll be happy to provide this to you. Normally we have a charge that we charge to our clients when we do it, but I feel like it would be definitely of some assistance to the folks here at Zulu who would be able to take advantage of such clauses and things of that nature. So last week we talked about how sometimes there's a delayed possession, or sometimes we may actually give our residential unit to the tenant early, as opposed to actually moving in when they should. So sometimes what happens is, in a delayed possession, for example, if the unit is being renovated, there may be a time when there's a delayed possession. So we always like to just include delayed possession in our additional forms of lease, so that the tenant knows that, heaven forbid, if something were to happen where we have become delayed in giving possession, that this clause happens to stay in there. So I know on real estate agent forms, of course, we're using standard OREA forms and clauses. These are really helpful for you guys. You can copy and paste and take this out of these clauses that we have here for you guys, so then you can insert them onto your form as well. Okay. Now, I always like to also include leases void without compliance. So basically what this says is, if you don't give me last month's rent, and if you don't do all of these things that you're supposed to do, providing insurance coverage, switching over the utilities, all of these things, then the lease becomes null and void and it can become terminated. Okay.
And sorry, Michael, just to clarify here, are these clauses that should be added to the Schedule A to our agreement to lease, or is this an appendix that should be added to the residential tenancy agreement?
This is an appendix that should be added to the residential tenancy agreement. So we call this Appendix B, additional terms to lease. So this is made pursuant to certain sections of the RTA that allow for additional lease clauses to happen. In these additional lease clauses, you can also include them on an OREA form if you're attaching the OREA form to the standard form of lease. So these may be additional lease clauses that you could just copy and paste into your OREA, or you can actually go through this, which I've taken the time to highlight what you should and should not include, you'll see further on, it'll actually give you options where it'll say, you may wish to include clauses highlighted in blue if this is your situation, or include clauses highlighted in green if the situation is this. So we actually took the time to help guide along, what certain clauses are helpful to landlords throughout forming the lease. Okay, and of course, those clauses are also helpful to real estate agents when they're helping their landlord clients form the lease as well.
Perfect. And before we jump in further into the clauses, what's the difference between the appendix and a schedule?
It's the exact same thing. Okay. So then we also cover things like rent discounts. Remember, we talked about, if you pay your rent early, I may give you a discount, but we typically don't like those. So we typically don't include things such as rent discounts, but we do include, so we, for example, may delete 3.02, and then of course these numbers change. And remember how I was talking about, where we have the different highlighted sections. So you may offer pre-authorized debit or post-dated checks and things of that nature. So there's different ways that we can set up the payment schedule. So on the standard form of lease, it says we accept payment in the following terms, right? So in here, it talks about, if you cancel your pre-authorized debit, or if you no longer pay by post-dated checks, you have to deliver the rent by the day in which it's due, but rent may not be paid in cash. We talked about that last week about the subsequent issues that come with paying rent in cash. Now, if prompt payment discounts apply on the standard form of lease clause, include number 7, which is inserting the paragraph, otherwise removing it. So we typically don't advise our clients to offer rent discounts, only because for accounting purposes, it becomes quite a mess, right? So when, for example, if you give a 10% discount if you pay early, we always love it when tenants pay early, but the issue is, it becomes an accounting nightmare. And especially if you go before, the landlord and tenant board, if something were to ever happen, is trying to explain through the ledger, oh, well, rent was paid early, so we gave a discount, and having to explain how we got to the discount, all of those things. So sometimes what I like to do is just tell our landlord clients, don't offer a rent discount if they pay early, just let them pay early, because it becomes an accounting nightmare for you. Okay. So of course, then, all of this would become removed. Now, on older properties, consider including clause 3.10, whereby the tenant acknowledges that there's potential noise from floors, etc. So this goes to, those sort of century homes that we have downtown Toronto, that were built maybe in the early 1920s. And we have a client whose building was actually built in 1908. And every time we sign a new lease with, between this client and the potential tenant, I always like to include this clause, because you can definitely hear more than just the noise of your tenant, whether it's upstairs or downstairs. And especially in these older properties, because, noise from neighbors can become, quite excessive, especially if there hasn't been much in the way of renovations. So for example, in the complex that we help our client with, some of the rooms have been renovated and they've, had new insulation put into them and things of that nature. But some of the units are really, really old and outdated and still have, that wartime newspaper sitting in there for insulation, right? So you can definitely hear other people. So I really like to include this in really old properties, just so that the tenant's aware, hey, you know what, we do everything that we possibly can, but I need you to realize that, possibly, your upstairs neighbor, you're going to be able to hear him creaking on the floors, at a certain time of the day, because the building is, 120 years old, right? And especially in those houses that, you know, are maybe designated heritage that you can't actually renovate and fix properly. This is really helpful for that situation. Okay. Now, there may be a time when you have, again, and I will go back to these older properties where there's only one single mailbox, right? So having to include these clauses about, you know, having a shared mailbox system and things of that nature really help, because what happens is, you know, you may have tenant Joe upstairs who gets all the mail for the day, but he doesn't realize that he takes Bobby's mail downstairs, right? And he may do that not maliciously, but sort of just without having any sort of knowledge that he may have taken it. So having the tenants acknowledge that, you know, if there's one single mailbox for the entire property, you know, talk to your neighbor to see if, you know, maybe they have your mail. People don't usually open other people's mail without, you know, looking at it first, but sometimes it does happen, which is a good reason why it's great to include if you have an older property, or if you have a newer property who, you know, you've just renovated the basement, but you've got one single mailbox. This is definitely helpful. Okay. And then we go in and we talk about things like use of premise, the description of the rented space and the shared spaces. And I find this is really helpful in, you know, properties where perhaps, you know, there's a suite in the basement and, you know, a family lives upstairs and, you know, the family upstairs utilizes the backyard all the time, but you don't want to give the utilization of the backyard to the tenant in the basement. So this talks about excluded areas and shared areas between people. You may have a shared laundry room facility. If, for example, in my townhouse, we have an in-law suite. We haven't rented it out, but, you know, if we decided to get a tenant, our laundry is actually separated between the bachelor suite that's there and, you know, our home upstairs, right? So that would become something that would be a shared area. And then, of course, you know, I may not want, you know, my tenant to have access to my backyard, so that would become then an excluded area. Okay. Clause 4.02, we should always use that the lease premises will be occupied, but no business other than requiring a simple home office will operate out of the home. So you don't want your tenant to do things like create an Airbnb or a VRBO, or I don't know, they start selling drugs out of their house, or you know, perhaps maybe, you know, they run their trucking company out of the house, and so, you know, the trucks are parked outside, and, you know, employees are coming and going and getting into trucks. I've seen that happen as well. So that clause definitely helps to mitigate those who are self-employed from, you know, creating some sort of business out of the home that could potentially be an issue. And the reason why you don't want them to do that is because your liability insurance as a landlord may not actually assist you in, you know, a situation where if there was a slip and fall and it was business related. And we talked about insurance last week, where I said it's always important to make sure that the tenants have their own insurance. But again, tenants insurance may not cover a slip and fall when it's related to commercial. So commercial liability insurance is completely different than residential liability insurance. And then clause 5, we talk about additional occupants that may be living in the property. And this is really important for the landlord to know, because in the event of an emergency, for example, if the house were to catch on fire, we may need to know that, you know, who were the children and how old approximately are they. And of course, this all assists you because, you know, you need to make sure that everybody is accounted for as a landlord, right? Additionally, in 5.01, this helps you in the event that, you know, if there's an unauthorized occupant that comes in and lives there and starts taking occupancy, and perhaps maybe the tenants move out, you've got a list of people that had originally lived there. which definitely helps in the situation where if you need to file an application to terminate the tenancy and evict an unauthorized occupant. 5.01 would definitely help you with that as well. In clause 6, we talk about responsibility for services, utilities, and appliances. So these are things like hydro, gas, water. What is the tenant paying for? In condominiums, typically these things are included except for hydro, right? So we talk about what should be transferred, what should not be transferred. And then we talk about in the event of a breach, if the tenants default and they don't pay their utilities, how we go about handling that situation is all covered in clause 6. Sometimes what happens is utilities will be paid and reimbursed to the landlord. So what'll happen is the landlord won't be able to actually transfer the utility account. And I've seen that happen sometimes. So what should typically happen is the landlord will then present a copy of the bill and the tenant will then reimburse the landlord. Or what'll happen is sometimes there's only one set of meters for an entire home. For example, there's one meter in my home, but I have 2 units, right? So what I may say to my tenant downstairs is I may say, oh, I need you to be responsible for 30% of my bill. Okay. I would deliver a copy of that bill and say, okay, now you owe me 30% of the $100 that this bill is. Okay. So this is all covered underneath these options. So you've got option 1, which is utilities would be paid directly by the tenant to the utility company, or you've got option 2 about having utilities reimbursed, or there's option 3 where if you're including utilities in the rent, which is very rare these days, but sometimes it does happen, where you would include all of option 3 and delete the 2 options above. Option 4, rent is included, but no separate charge by a monthly cap rate. So a monthly cap rate is, for example, if you're on equalized billing and you decide you want to include that, but then equalized billing comes further in the next year where it's been raised substantially, you can put a cap rate on the utilities. And then you can say, if it comes past this amount, then you're going to owe me for the difference in the cap rate. Okay. And we talk about appliances and things of that nature that are included in the standard form of lease. So refrigerator, stove, clothes washer, all of these things that are included in there.
Speaking of that, what about the furnace? Who is responsible for furnace filters?
Right. And this is always a good question. So the landlord is actually responsible for replacing the furnace filters. Okay, because it's reasonable maintenance and repair. And I'm just looking at Lisa's question, which is a great question, because sometimes what'll happen is the condominium corporation may come around and replace them, right? Now, keep in mind, your landlord client should still be getting notifications regarding the changeover of the furnace filters and things of that nature. And you're still obliged to give a 24 hours notice, even though it's the condo corp that may be coming in to change it, right? And the condo corps, what they don't understand is, sometimes they have tenants that live in their buildings, right? So they still provide a notice that says, we're coming between 8 a.m. and 8 p.m. to change your furnace filter, which doesn't really help. You got to try and narrow that window down just a little bit. So if you can, speak with the condo, the condo manager to say, hey, listen, I need a narrowed window when you're going to come in, because I got to give my tenants 24 hours notice. They'll usually say, okay, well, we should have, let's say, the 15th floor done by 9 a.m. and we'll be down on the 14th floor by 10 o'clock. So then you can sort of budget, between 10 and 12, which is more reasonable, right? Sorry, I'm just reading here.
Yeah, we have a few more questions coming in.
Yeah.
And Revan also asked earlier on, we skipped this question, I was going to leave it to the end, but he says he has a tenant since 2017. Should he be giving him the Ontario standard lease?
No.
Okay. And then, yeah, again, his follow-up question here. So usually we send the Ontario standard lease after accepting the offer. Isn't it better we include these clauses in Schedule A or C or as a separate appendix and ask the tenant to sign it in the beginning in case after accepting the offer, tenant doesn't sign it?
I think that's a really good idea, because then you automatically have sorry, I'm trying to look for it's a meeting of the minds. And I was thinking consensus ad idem, which doesn't mean anything to probably most people on here. But there's a doctrine called consensus ad idem, which is a Latin doctrine for a meeting of the minds. So the sooner you can get the two parties to agree to something, which consensus ad idem is essentially how we start a contract, right? I'm going to agree to something and you're going to agree to it, and there's consideration that's going to be passed. So if you can, Raman, get them to agree prior to signing the OSL, then that's the better option, most certainly. You're presenting the offer to lease, you're presenting, here are the lease terms we want to enter into. Do you agree to these lease terms? If so, great, then we can sign the OSL and attach all of this, which is probably your better option to go.
Perfect, thank you.
You're welcome. And then always include 6.09 for shared internet services. And this happens all the time because, and I'm sorry, because I'm going to go back to our situation again, where there's only one phone line service, which means I can only have one internet connection in my house, but I have a separate suite, right? But you can't hold me liable if your Wi-Fi access doesn't work, right? I'm going to give you credentials to Wi-Fi, but if they don't work, don't hold me liable for it. Basically, this is what this is essentially saying is, we agree to share it. Don't look at my stuff. I won't look at your stuff. But, if the internet goes out, sort of not my issue, right? I won't do it maliciously. I'm agreeing to say I won't do anything maliciously, but, essentially at the end of the day, I can only control what I can control. And I agree, I won't remove those services as a part of your lease, right? And then clauses 7 to 7.02 specify the rules in Appendix C, which I will go to as well in a little bit here. But what that basically is the rules of the house. Make sure that you keep your premises in a neat and tidy situation. The rules may also state that there are certain rules with a condominium corporation, and we talked about pets last week, where maybe your dog can't exceed 8 pounds and it only can be orange, and you can only have 2 cats, and 3 fish. So all of that stuff gets included in this sort of rules, right? Because we want to make sure that the tenant is aware that there may be additional rules and regulations above and beyond what's tying me to you, because as the tenant, you have an agreement with me, but I may be in a situation where I'm part of a condo, and the condo will only let me have certain types of pets, etc. Right? That also then flows through to the use of common elements, smoking rules, things of that nature. Okay. The landlord's covenants and obligations, which are these are all in black because these are standard to the Residential Tenancies Act. So we automatically include all of these. And, basically as the landlord, I'm agreeing, to provide you with a residential unit. I agree to, upkeep, reasonable maintenance and repairs, and to not withdraw any services. And then as a tenant, you're agreeing, to make sure that your rent is paid on time, you pay all your utilities, You conform with standard bylaws, whether or not, those are municipal or they're formed within a corporation, a condo corporation. And, the tenant shall not do things like perhaps maybe mount TVs to a wall, things of that nature, okay? And then we talk about things about, if parking is provided, these clauses in 9.9.15 and beyond here are great to identify, if there's parking included, where are the parking spots? How many parking spots does the tenant have? And it may be very so that, if it's a shared driveway, for example, the house may have a shared driveway and it's got 4 parking spaces, but 2 of them need to be utilized for, the people living upstairs, and another 2 can be utilized for the people living downstairs. Okay. And who gets access to the garage, things of that nature, right? These clauses in 9.18 and beyond refer to things such as laundry, how you can access the laundry, what hours the laundry facilities are open. Again, this goes back to, I was talking about, how we have a shared room in our house where, if we wanted to give it to our tenant to use, they may say, well, you can only do, we can only authorize laundry use on Sundays between, 12 and 4 p.m. because I need it the rest of the time, right? Sorry, Lisa, in general, the tenant signs a lease with additional clauses that are not enforced in the law, so the tenant decides what they by these periods. So Lisa, is your question related to clauses that may be in contravention of the act?
Kind of, yeah. It's just sort of if there's something that, okay, like, if they're not allowed to say, you're not allowed to ask for deposits, but in the agreement, if the landlord writes in there that, yes, you agree to, give, further deposits or anything like that. And one day you decide, no, I've decided I'm not going to do that anymore. Are you allowed to do that? Or do you know what I mean? That's it. Yeah.
Well, and this is sort of what we were talking about the first go around was.
Sorry.
Yeah, no, I think were you on the last 2?
No, sorry.
Okay, no, so let me catch you up to speed. So a tenant can consent, however, always, however, I would highly suggest getting an ILA certificate. So you're not supposed to take more than last month's rent as a deposit.
Yeah.
Okay, and the key deposit has to be reasonable. Okay, so you can't ask for a $500 key deposit when it costs $100 to change keys.
Yep.
Okay, and you can't ask for a pet deposit. But if your tenant is saying, I'll give you 6 months prepaid rent and first and last, so we're talking about 8 months worth of rent, right?
Mm-hmm.
The tenant can consent to waive that. However, the issue then becomes that the landlord is in contravention of the act because he is carrying more than last month's rent.
Right.
Right. Now, there is a part of the act where the act does say save and accept on consent. I'm summarizing that, save and accept.
Yeah, that's fine. I get it. So if you've given consent, then it should be.
Then it should be okay. However, we all know how difficult tenants can be sometimes, right? So the tenant can say, I didn't consent to it. I was forced into it because my real estate agent said I wasn't going to get the property unless I consented to it.
Yes, that's right.
Right? Go and have your tenant get an ILA certificate to say that it's been explained to them, that they're agreeing to the consent, that they're not being coerced. An ILA certificate costs about $150 to $175, right? Have the paralegal, have the lawyer sign off on an ILA certificate saying, we explained everything, they're agreeing to it, I've met with this person. In a roundabout way, everything is, forgive the expression, kosher.
Yep.
But we can move on from here, right? Because that at the end of the day is what's going to save your bacon when it comes to the landlord and tenant board.
Okay, got it.
Okay.
Can I ask one more quick question then?
Sure.
a little bit off the topic, but when it comes to a lot of times people are asking to meet with the tenant or see photo ID. And my understanding is it might be a human rights issue that because if they see the tenant and they don't like the way that the tenant looks, that they can, and if they don't give the tenant the lease, then that could be problematic.
Yeah, so what I always like to do is I like to include, just 1 second, Anna, we'll get right to you. What I like to do is at the end of the transaction, I will give everything to my client, the landlord, right? So I'll say, here's your executed lease, both of you signed. Here's your tenant's ID. Here's everything, because they need the ID anyways, right? Because they need to be able to validate that the tenant that's in there is actually the tenant that you rented to, right? And you do the work anyways to ensure that the tenant is who they say they are.
So you are allowed to ask for photo ID then?
Absolutely. I actually encourage our landlords to ask for photo ID.
Okay, because I thought that could be a human rights thing. If someone doesn't like a certain ethnicity and then say, no, forget it, or
well, and that's why
that does happen.
And that's why you give it to them at the end of the transaction, right?
You mean once they've already
signed everything?
Okay.
Right. So the consensus ad idem has happened. They've all signed everything. The consideration has flowed, right? You've been paid, the landlord's been paid, the transaction's closed, right? Here's your signed documents, here's your tenant's ID. Because what's going to happen is, for example, say the tenant defaults, right?
Mm-hmm.
We issue the N4, we get the eviction, we get them kicked out. How do we get the money?
Right.
We have to traverse it to small claims court. But now the issue becomes the tenant's left. How do I serve them a garnishment? How do I serve them this? How do I serve them that? Right? So if the landlord has the ID at the end of the transaction, so they have no prima facie reason to have a bias, right?
Okay, so as long as, so you have to, but okay, so just so I understand, you're only allowed to ask for the ID after they've already agreed to, after they've signed the agreement to lease. Is that sort of?
So what I would do as a real estate agent is I would get the ID from the tenant anyways, right? I would hold on to that until the end of the transaction and hand it over to my landlord.
Okay, that's what I want to know. Okay, so
Yeah.
Yes, because that's what I understand, is that you're not allowed to refuse somebody just because you look at them and you go, you know what, no thanks. So
yeah, exactly. And you want to avoid those issues because that can be a huge issue, right?
Absolutely. Okay, so sorry to interrupt. I wanted to make sure I asked you that. So
no, that was an excellent question. Thank you so much.
Can I ask a question now?
Hand up. Yeah, we've got Mohammed in the chat as well. So a couple more questions coming at you.
Absolutely. Can we just start with, I believe Anna raised her hand just prior. So Anna, did you want to come on? And then we'll come to Mohammed.
Yes, I do. I kind of want to continue the question that Lisa asked. Can you hear me?
Yes.
Hello?
I can hear you.
Can you hear me, Mike?
Yes, I can.
Oh my God. Okay, so I want to ask a question. One of the listing agents asked to see my client prior even sending the offer. And it happened twice. And I knew already that she was representing her mom. And she didn't want to send me consent. And I said, like, I'm sending you all package with ID, offer, everything. And only after your mother, basically the landlord, can see my tenant. On what she refuses, like, no, we want to see the tenant before even sending an offer. how can I be on the side of my client who is a tenant to defend, but still not to lose a deal?
So, yeah, that's really hard because, you know, they again, they may form a bias, right? And we don't want them to form that bias. So at that point, you might not even want to deal with that particular individual. And I would bring up the issue and say, look, you know, you may form a bias against my tenant, and I believe that the best way to handle this situation is to act professionally. You can go through my documents, you can review the income, you can review, you know, my lease that I have prepared. You can decide whether or not you want to take my client or not. But unfortunately, you know, I have a duty to ensure that, you know, my client's rights are protected, and you have to ensure that your client's rights are protected. So we need to act accordingly, and I can provide you with XYZ. If that's not sufficient for you, unfortunately, we have to move on, because you don't want to put your client into a situation where, you know, they could have potentially had that property, but then a bias was formed.
Yeah, like everything was perfect with my client, and eventually I asked how badly you wanted this property, and he's like, I really wanted this property. So I asked him, like, that's what they asking for you to go and meet, and he went and he get the property. But it happened with that specific listing agent twice on the different properties, and like, if the paperwork is perfect and I double check the income, everything by formulas, and people make even more than they can, they ask for the rent, right? I don't want to be that agent who is sending my clients to the office every time I deal with the listing agent who is asking for that.
Mm-hmm.
Like, what should I say specifically to the listing agent to make sure, like, is it violation of the rules, you know, like?
It's not, but you also need to be able to protect your client from potential biases, right?
I have to change the room. So.
You just want to be able to protect your client from potential biases, that's all.
Yeah, we're getting a comment here from Arena as well. She just had the same thing happened. Perfect clients rejected based on their nationality, race. I didn't know that we could hold off from sending their ID until the end of the transaction. So.
Oh, Irina, I'm really sorry to hear that. If you want to have your client speak with our office, that we would be happy to discuss the possibility of an HRTO case. Okay, we do human rights here, so we'd be happy to discuss that with them. And just so you're aware, Irina, it's, we act on a contingency type basis for those types of matters, because we realize often those people don't have lots of money to sort of go and fight those large cases until the money comes at the end. And then I'm sorry, Anna, I know you got cut off because your connection was bad. My client was refused because she had a C, and that's inappropriate as well. Just because your client has a child doesn't mean that they should be refused. Based on race, because the landlord needs property back for family, and he's going to take the listing down, which he hasn't. Yeah, that's good enough in itself, I think, Irina, that, if we can sort of monitor the listing and see what sort of happens, if the listing ends up dying, or if, it gets rented out, usually you can tell, I think, through the board whether or not, it's been rented out. I definitely would monitor that listing. Something doesn't seem right.
Yeah, and I'll just read that so that everyone gets that. So the agent didn't openly state that it was based on race. He said it was because the landlord needed the property back for family, but the listing hasn't been taken down. So yeah, good idea to monitor that listing.
I have to go and I want a cake.
Oh, and then we've got Mohammed who's waiting.
Yes, sorry. Yeah.
Yeah, my question is, sorry. Is it me?
Yeah,
Yeah,
I
go
can
ahead,
hear you,
Mohammed.
Mohammed.
Okay. As I understood from your talk that the ID can be presented at after the acceptance of the offer.
Yes.
But most of the time, listing agent wants offer should be submitted along with the IDs. So in that case, how you are going to make sure that, because what happened, I submitted twice with the two listing agent for two different clients. They did not bother even to respond, acknowledge the offer. Forget about rejecting it, did not even acknowledge. I tried to reach the agent through the office, but never ever responded my call or paging, email, doesn't matter. So it is for sure there is something that by looking at the IDs, they are making the decision and decided not to even respond.
That's a little too sad. And that's why I was sort of trying to explain, before that, sometimes it's best to hand over those things at the end. I know sometimes your hands get tied because it says, offer must be accompanied with ID. But I would just simply, pick up the phone and say, hey, listen, I need to ensure that, my clients aren't going to be prejudiced when I send over the ID. So we will send the ID in a final package, or the agent must then maybe perhaps recognize that there could be some sort of bias there. And sometimes it's just talking through that professionally to ensure that a bias isn't going to take place, because you never know who you essentially deal with, Mohammed. It's kind of sad still, actually, that there's people that still go through these things, right?
Yeah, and Raman has his hand up.
Yes, go ahead, Raman.
Hi, Michael.
Hi.
Should I have a question regarding my first question that I had, just a personal thing. I had my tenants that before I become a real estate agent since 2016, 2017. I didn't actually give, it was before the rules about the Ontario Standard Form. So I'm wondering, even I have to give it now, or if I give it now, it will be any problem for me if they say that he gave us too late or after 2-3 years?
No, Raman, you don't have to do anything, because your lease that you have with those tenants who are in there right now has gone month to month. And the importance of recognizing the fact that we can't renew leases, we can't put people into new leases after their lease has expired, because the Residential Tenancies Act provides for security of tenure, which states that, essentially the tenant goes month to month after the initial term of the lease. So you don't want to tie them into another lease. And in fact, I've seen it where a new lease has been provided, and perhaps maybe there's material changes to the original contract, which then essentially becomes an issue, because the landlord tenant board can actually order that the landlord is in contravention of the act and subject to fines. So you could just leave it the way it is. It's perfectly
So
fine.
I don't need to give them Ontario Standard lease.
No, not at all.
Okay, thank you. One more question, very quick. Just
Yes.
if they actually, regarding the credit score, if we get the permission from the tenants that we can check their credit score, is there any website or organization that we can get a credit score for free, or we can check every details or background from the tenant? For the tenant?
No. So your tenant can provide you with a free report from like Borrowell or something like that. But what I find with these Borrowells or the Credit Karmas is when you download the PDF, you could actually break the PDF, because the PDF is not a secure PDF. So when that happens, they can change the credit score anyways. You have to have a membership number with Equifax to pull credit reports. So and those reports come at a cost. Our firm pays for those costs for our landlord clients. So if you wanted to, like we charge a $250 screening fee, which covers the Equifax report. It covers the underwriting of the deal. It also covers us looking at freedom of information to see if they've ever been before the landlord and tenant board before for other issues. because you want to make sure that if you're getting a tenant, you're getting a good tenant, not a tenant that's going to become problematic, right? So the minute I see, for example, if I do my freedom of information request, you know, and my guy's got a 700 credit score, but he's been before the landlord and tenant board 3 times for non-payment of rent, I'm not going to give him the unit.
Yeah.
Right. But you may not have access to those things, but we definitely do here. And that's a service that we provide to landlords. And we're definitely happy to partner with you folks if you need assistance with those services. That's what we're here to help with.
Okay, thank you so much.
You're welcome.
Awesome. Lots of questions coming in. I know we were talking about, I don't know if you wanted to highlight a few more of your clauses that you have included there, or if you'd like to just open up the Q&A.
It's okay. We can open up the floor, but I'm going to share this with you guys anyway. So Jane, I'll be happy to flip this in an email over to you so
Awesome.
you can
Thank
share
you.
it with the team.
I'll
Okay.
appreciate that. Okay, so Naeem is asking, for what reasons can the landlord evict the tenant? And I will just say quickly before you answer that, we're going to be dedicating, I believe, all of next week to that question. Is that right, Michael?
That's correct. So that'll be covered next week. Okay. But very quickly, non-payment of rent, resale of property, persistently late payment of rent, demolition of the property, illegal acts happening inside the property, and nuisance. But
Awesome.
we'll get into all of that next week.
All of that coming up. So Lamchi is asking, is there a negotiated decrease of rent due to market conditions after the initial lease term, for example, during COVID? Is it legal to have the tenant sign a new lease?
Nope, don't do it. Short answer, nope, don't do it. And I'll tell you why. Because what happens is, so for example, and I think we covered this at 1.2, very briefly we covered it, where the landlord was leasing for $2,100. He drops the rent down to $1,500 to assist the tenant, right? Then the tenant says, well, I'm not going to pay $2,100 anymore. I'm going to stick to my $1,500 and there's nothing you can do about it. Guess what? The tenant's right. So unfortunately, the tenant is still right, because now what's happened is you've decreased the rent and what you've done is you've actually formed a new rent payment. So the lawful rent then becomes $1,500. So here's what you do, okay, is if you're coming up with a rent relief for your tenant, you always say to your tenant, the lawful rent will always stay at $2,100, but for the next 6 months until you can, get back on your feet or whatever the issue is, or if it's due to COVID related issues, the rent will stay at $2,100. Please pay X number of dollars if that's $1,500, right? And then at the end of the 6 months, so long as you have that agreement noting that they know about that, then you're good to go. At the end of the 6 months, don't let your tenant consistently pay $1,500. They have to pay the $2,100, and you're going to show it as a write-off. So the landlord is going to show the difference between the two rent prices as a write-off on their ledger. Okay, so if they end up at the LTB because they
okay, I have a question. Like if the tenant gives the number plate of a car and he doesn't have that number plate and somebody else parked the car, and you see this continuously for 3 months, 4 months, and he says he doesn't have a job, but then his friend is coming, and in the landlord tenant thing, they say he has only one car and he's living only by himself, nobody else. And then when you see there's a lot of things going on, like prostitute and everything going on inside, a lot of people coming every day, new girls are coming inside and doing prostitute in the property. And and then how do we complain that some people complain, the neighbors complain that some prostitute going on in this house at Friday, Saturday. So how do we handle with this? Do we complain to the police and complain about the license plate, which he say he doesn't own the car, but then somebody's car is parked in front of the property, and now the landlord went to the landlord tenant board. He never paid for 10 months, and then what he has to do is he has to go to the court to evict him out, and then once he left, and he has his driving license, but we cannot do anything because he doesn't own car, he doesn't own anything on his name. So this is how this comes up in future. So we have to be very careful with tenants, especially a lot of tenants, they don't have credit score, they come new, but they say that they are going to pay for 3 months and they don't have a job. We have to verify. This is a lot of stress for us.
So to jump back onto the illegal acts, we'll cover illegal acts with respect to an N7 next week, which is going to be about terminating the tenancy, right? So the illegal act of solicitation and prostitution would be covered under an N7. However, I would ensure that, you know, I had some sort of police report at least filed with an incident number to demonstrate, you know, that, you know, an illegal act is continuing to happen in the property. Now, understand that there's a case called Metro and Ball, where in Metro Ball, they state that you have to be very descriptive. So when you're filing that N5 or that N7, you really need to have descriptors. So things like, you know, 9:34 p.m., vehicle plated ABC 123, blonde woman wearing short mini skirt, color, blah, 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 entered the property, was seen carrying cash upon leaving the property at this time, right? So you can actually demonstrate the solicitation or the prostitution that's happening, right? And I'm sorry, I didn't think that randomly, I'm just randomly picked a hair color and eye color. It honestly, you have to be so descriptive in order to be able to be successful in a case.
So we have to watch them as a private investigator, sit there and watch what time they leave, what time they go, and do your homework and then give it to the cops.
Not necessarily. What I'm saying is, if your neighbors are going to help you with that kind of stuff, then that's great.
Oh, they don't want to go to the court and all those stuff. Okay. I already spoke to them. They said we don't want to involve in this because we have our own life. We are just trying to help you. But the problem is, how do we do have rights that we can watch them 24/7, and also he's smart. He put camera outside. Whoever goes by, pass by, he checked from the phone, and whoever ring the bell, he checked the phone. You know, and he knows what time who's coming. We give 24-hour notice. He allows us, and then he's not there at the property.
Okay.
And he opens the door with his phone, and we go inside and check. And by the time we come, everything is cleaned up.
Wait, so my next question is, has he changed the locks?
No, he never changed the lock. He has he took the Rogers thing, and he took that authority that I will pay for this. Rather, you are paying, the landlord is paying, so I will pay for it. And he took the charge of that lock and camera.
Okay, I think actually what we should do is you and I should have maybe a more fruitful conversation offline.
Okay.
Where we can give you some better advice.
And also, I see a lot of people, they call me, oh, I'm looking for this property. If I tell them, oh, can you fill the rental application? They say, oh, I'm not going to give you documents. Why do I need to give you my information? I said, listen, I'm a licensed realtor. You need to fill up this form. We have to do your job. You have to fill up, and this is what we require to do your job. I asked them whether you are working with another realtor. Oh, because you're not active, so I have to hire another agent. You cannot do this. If you're hiring another agent, then you're wasting my time and the other agent time. So make sure so this is what a lot of things happening now. And sometimes they tell us in the phone, oh, I do this job and that job. And when you go there, oh, can you show the property? I'll bring the document. When I go there to the property, they don't bring the documents, and they see the property and they go directly with the client.
Yeah, so if they don't, like, if my prospective tenants for my large landlord clients, if they don't give me what I'm looking for, I won't even talk to them.
And they try to be like aggressive, like, oh, well, why do you need the document? And they start yelling and abusing me. So there's any right that we can record everything and give it to the thing that they're taking it to the other level if they disrespect the agent? And we are doing the job. I'm new to this. I'm coming from America. I don't have a credit score, but I'm willing to pay 3 months. I have an IT job. But then I said, I have to find out whether your category, it suits with the thing. Give me 1 day time. I will get back to you. Then after 1 day, next day I went and spoke to him. Listen, I'm trying to call him. He's not picking up. Or he is saying, oh, I left my car, left my phone in the car. So I forgot. First, he said he doesn't have a car. Now, how did he get a car? Maybe he got a rental car or something. I'm not sure. But then he's lying again and again. And he's saying, okay, can you send me the properties so that I can check whether it's suitable for me? I said, this is the area I can tell you. Just fill this up and then I can send you. So I don't want to give any information because he's a customer. He's not my buyer. So why do I need to give him information which is not going to give me rental application before ahead? And then I told him, can I meet you? He gave me the address. I wanted to go meet him. I don't want to meet him. Then he can say, oh, you're trespassing my property, and he can call the cops.
Yeah, Imran, just a couple of takeaways there. If you have somebody who's not forthcoming with documents, it's probably that they're not qualified. The great thing here is you have lots of leads coming in, so just move on to the next.
Yeah,
no,
exactly.
ma'am. Yeah, a lot of this kind of people, they're like students. You know, they want a house with 6 people under one name, and they are not family. They are like roaming students.
Yeah, and in that case, you can always refer them to Facebook Marketplace or Kijiji. You know, we try to help everybody, but not every situation is going to be easy, right? So in some of those cases, you just have to refer them directly to
and then I
Facebook.
book an appointment. I'm trying to call him 5-6 times and he's not showing up, and then I have to cancel the appointment. And then he calls me at 10 o'clock and he says, oh, listen, we found another property, just cancel that thing. After 5 hours we got another property. Then he wasted almost 1 week of my time showing him the property, filling him the documents and everything, and now this is what happened.
Yeah, it's the nature of our job sometimes, but yeah, like I said, just on to the next. You'll have another tenant that you can work with. Michael, I just want to throw it back to you to see if there's anything else in the chat that you wanted to address.
I'm just having a look at May's comment about a PI. So if you actually did need those services, we do have investigators that we do work with. So if you've got a tenant who is doing things that are illegal in the property and you really need to sort of nail that down, we do work with private investigators. Additionally, you know, maybe we need to locate a tenant after they disappear. We definitely can assist with that as well. Okay.
All right. And I threw in a clause in the chat here, just wondering on the topic of lawful and unlawful clauses, this was something I came across in a landlord's requested Schedule A, that should the tenant at any time purchase the property, that the landlord agrees to pay the agents their commission. So I was wondering if that was allowed or if it's neither here nor there.
Should the tenant at any time purchase the property, the landlord agrees to pay the agents so named in this agreement or their successor companies a fee of 4% for the purchase price. For this fee will be split equally amongst the agents of the named agreement. That is the weirdest clause I have ever seen in a rental agreement.
Yeah, that's why I threw it at you there.
Delete. Yeah, that's a big no. Because honestly, I mean, we don't know if that's ever going to happen, and you know, sometimes landlord clients do nice things for their tenants. For example, you know, I
have a question. Like,
let me just
how much do you?
Sorry, go ahead, Michael.
No worries. So I have a client who has several units in Art House in Markham, and I know for a fact he sold one of his units to his tenants, so he actually gave them a discount upon purchase. But that wasn't something that was in the residential lease agreement. That was just something that he did out of the kindness of his heart, and he wasn't obliged to do so. But a clause like this to insert into a residential lease agreement is not lawful in accordance with the RTA at all.
Okay, great. Awesome. Thanks for answering that.
Okay,
Well-
I have a question. How much is the private investigator charge if we need something like this?
So that all depends. Again, that would be a good offline question for us to have a conversation about. So you're always welcome to call the office. So we can give you price quotes and things like that, because I'm not the one that unfortunately gives those price quotes. So
No,
we have
if our client asked about this, okay, we can give you this service. If they ask us, so what do we reply them? So this is a good question to have a backup plan. If the tenant is not paying the rent, I have a lawful place who can do private investigator. And if
Yeah.
they ask how much do they charge, I need to know the,
absolutely. So what you're going to tell your client, Imran, is you can call the offices of Solomon Jones. They'll be happy to provide you with a quote. They're giving you 30 minutes free consultation anyways, because you're a Zulu client. So you don't have to worry about that. We'll deal with it from our side. Because I don't want other people quoting our legal fees when we don't know what they could possibly be. We have a large client services staff who is able to ensure that proper quotations and stuff happen, because every case is different. So
okay. So I have to I have to tell my client, go talk to my office. They can help you regarding the private investigation, anything.
Yeah,
We
exactly.
shared the link there in the chat. So solomonjones.law is where you can find Michael's contact information.
Okay. And I think we have one question from Anna. She looks like she's got her hand raised. So why don't you go ahead, Anna?
Thank you. I have a question. If the lease already signed and tenants moved into the property, the landlord doesn't speak English, but he has been represented by his friend who speaks English. And the issue between a landlord and tenants that they cannot communicate. So listing agent still contacts me for like little details and questions that I told, like, now the landlord and tenant has each other's contacts and they can communicate between themselves. You know, like I'm still helping, but I wanna to know at what point my dues already done. You know, like I will help if I need, but I wanna know, you know, not to waste my time and their time if they can communicate between landlord and tenant or friend and tenant.
Yeah,
I have to deal with this situation.
As far as I'm concerned, you don't, you know, and this is me looking out for your best interest. I would step away from that situation, because the game of telephone can turn out to be a very bad situation. And I would just say, you know what, I'm happy to assist with, you know, with issues regarding the lease, but if this is what is persistently happening, my duty sort of ended after I put the tenant in the property. And, you know, my duty only continues, you know, if you need severe assistance, and this is not something I can help you with. So you're going to have to figure out how to communicate between each other, because the last thing you want to do is, you know, have an error or an omission that happens, and then it raises potential for insurance claims. Anna, honestly, I would just sort of back away from it.
But what for my client, for the tenant, what should I tell them? Like, if you're not satisfied with the landlord, you can go to tenant landlord board. Like,
no, what I would say would be, you know, if there's issues between the parties, try talking with, you know, perhaps maybe a legal professional who can guide you a little bit better. We do have a full staff here who speak multiple languages. I'm Polly. I've got my business partner who is bilingual. We have another gentleman on staff who speaks 3 languages. So we're pretty much covered in this office for lots of languages. So you know, if there's sort of a language barrier or a language break, we're definitely able to assist. You know, and if we're not able to help, then, you know, we know lots of people who speak with lots of languages too, that we can always outsource things to. But for your sort of situation, I just wouldn't get involved, because I wouldn't want to see you get an errors and omissions claim that could possibly cost you, you know, down the road.
Thank you.
You're welcome.
Thank you so much, Michael, for addressing everybody's questions. I look forward to next week. So hopefully everybody will be able to join us again. And until then, yeah, thanks so much for joining. I have attached the link, as I said, so if you want to reach out to Michael directly, just go to solomonjones.law and you'll see all their contact information there.